I guessed bigger.
Okay, I just put my stuff down, but I wasn't sure. Okay,
Sure,
all right,
that's
well,
fine.
all right.
All rise. The Court of Appeal in for the Fifth District of the State of Florida is now in session. The Honorable Carrie I. Commander, Judge, presiding. All persons having business before the court draw near to the attention and you will be heard. May God save the United States of America, the state of Florida, and this honorable court. Please be seated.
Okay, good morning. We're here on for oral argument on the case of Roxanne Eady versus Adam Gillis, case 21-3054. These arguments are being live streamed so the public can view them. Also, I want to introduce the other members of the panel. Seated to my right is Judge Jay Cohen. To my left is Judge Dan Traver. They have served this court very well. This is their last in-person oral argument on the 5th DCA. They're both moving to the 6th DCA starting in January, and I just wanted to thank them for the service, and they're both excellent judges and have been great colleagues, so I'm going to miss them. So that puts the pressure on the attorneys to make sure this is a good last oral argument. So we'll go ahead and start in just a moment. If you have any cell phones or any other electronic devices, make sure they're in the silent mode. You each have 20 minutes for oral argument, and appellant's counsel, you can let me know how much time you wish to reserve for rebuttal when you approach. And with that, let's hear from the appellant.
May it please the court, this is Mary Fleming. I represent appellant Roxanne Eady. I'd like to reserve 5 minutes, please.
Okay.
This is an appeal from a dissolution of marriage action. Ms. Eady was the primary caregiver, and yet the court awarded primary time sharing to Mr. Gillis. We've identified a number of errors requiring remand. I like to focus on 3 today. First, the court improperly disregarded evidence of a physical altercation between Mr. Gillis and his son. Second, the imputed income to Ms. Eady is more than she has ever earned. And those 2 errors are indicative of a third, broader problem in the judgment, that the court did not exercise independent decision-making. I'd like to start with the first 2 because they're independent bases for vacature, and they are examples of the broader problems in the judgment.
Can I start with just what I think is probably a pretty straightforward and easy question? On the imputation of income, it didn't seem to me, and maybe I missed it, that either you or your colleague cited the statute, 6130. I mean, it seems if I read the statute, it says that that a trial court cannot impute income higher than the highest income somebody's ever made unless it is theoretically subject to a couple exceptions that don't apply here. 1, a degree or a relicensing. 2, that the income wasn't higher than the median in the census. So it seems in this case that even though nobody really cited the statute just controls our outcome.
We agree. That was an oversight. We should have cited it, but yes, we agree.
Okay.
As to the altercation between Mr. Gillis and his son, the court was required to explicitly consider evidence of domestic violence or child abuse.
Well, let me ask you this. If the court accepted the husband's testimony, would that establish domestic violence?
So our position is the court should have explicitly addressed testimony from the son, and it didn't do so. And the court didn't make a credibility finding or otherwise as to whether it believed the father or the son. And we cited a few cases where there's evidence of this kind of conduct.
Yeah, but back to my original question, though. If the trial court had accepted the husband's testimony about the events of that evening, would that have established domestic violence?
I'm sorry, I misunderstood the question. Yes, I think so. Under statute 7, chapter 741, chapter 28, or section 28, excuse me, domestic violence is defined as battery or assault by one family member against another. Also, to get an injunction.
If you grabbed a phone or some other item out of a child's hand, that would be domestic violence?
Well, there was testimony and evidence that the son suffered.
I'm taking it in the light most favorable to the appellee.
Well, there was undisputed photographs of the bruises and the scratches that the son suffered as a result. The other side doesn't really dispute those. And I'll also note, under the domestic violence statute, a party can get an injunction if there's a reasonable fear of domestic violence, and that's certainly established here. The son repeatedly testified he was afraid of the
But
father.
you're not talking about injunctions, you're talking about something being termed child abuse. And the testimony given in the light most favorable to the appellee is that there's a dispute over a phone, that the father doesn't want the son to have the phone when he goes to bed. And the son refused his demand that he turn over the phone. That, in your mind, constitutes child abuse? Because it sounds like parenting.
We think that the court should have at least addressed it. And right now, this court is left to guess as to what the court actually.
I think in the Second Amendment judgment, and perhaps the first, and I know you're going to get to that in a second, but it seems to me that in the Second Amendment judgment, the trial court just said that there was no competent evidence that was adduced under that particular factor. And I mean, look, you're in front of a panel where all three of us were trial judges in family law divisions. We get that in divorces, heavily contested or otherwise, there can be two different stories about a particular account. But if a trial judge says, I find this side to have not adduced competent evidence on this particular factor, I don't know how, it seems to me that it would be really challenging to get around the abuse of discretion standard. You know, as it relates to your second issue, I think it's pretty indisputable that you're dealing with a pretty high standard. So I think that's kind of the spirit of the questions that you're getting on the quote-unquote domestic violence issue, because it seems pretty clear that the trial judge didn't believe it was domestic violence.
So we're not actually challenging the court's finding on that. It's more of a first step question. Did the court consider it and demonstrate in the order that it considered it such that this court can adequately review it? And in fact,
Can I throw out another possibility? You know, these final judgments are public records and they're out there for a long time, and I suggest judges are reluctant to put in writing for a long time that a child, you know, it's different when it's a party, but that a child has not been honest with the court, if the judge found that. I'm not saying the judge did. So by stating something like, you know, I've considered the evidence and find there's not competent evidence to show domestic violence or this factor, you know, that may be an approach many judges take to protect the child in the future. I'm just throwing that out for your consideration.
sure, and the court could have addressed it in a delicate way. I think just acknowledging the son's testimony and that the court did not find it credible arguably would have been sufficient, but there's just absolutely no mention of it in the judgment.
What would your remedy be? Remand for the making of those findings, and what does that do for you? And what does that do for your client?
Well, it potentially changes the outcome on the time-sharing factors, on the best interest of the child factors, which would affect the time-sharing determination. And on that point, the second problem here is that it's not just on factor M, it's that the court failed to appreciate how this incident infected all of the other factors.
Now, this was, you know, my understanding, you know, I can tell you, we all have read the transcript of this trial, which was lengthy. And it's my recollection that there had been no other incidents, no other allegations of child abuse, that this was a one-time dispute over a cell phone. Do you agree that that's the state of the record?
As to the son, yes, the mother did testify as to some abuse against her.
I understand.
But as to the son, yes. Just on the infecting the other factors, the problem here is The court repeatedly faults Ms. Edie for not complying with the time-sharing factors, and she was really between a rock and a hard place. There's testimony that the son would refuse to get out of the car, that he was afraid of his father.
He was bigger than she was. We understand that.
Okay.
But the time sharing went, way beyond that. It went to, your client's conduct in terms of following court orders and in terms of allowing a relationship between the father, even and the daughter, correct?
Well, that's the issue, though, is that a lot of that is overshadowed by this incident and the fact that the child was not cooperating, didn't want to go to his father's house. There is evidence that my client encouraged.
Right, but previous to this, when your client initially left the home, she left the son with him.
And I think that's evidence that before this happened, she was willing to facilitate a relationship with the father, but things could change when.
Also evidence that the father and the son had a good relationship.
Sure, that was also 4 years before this incident occurred, so, I mean, time passed and this happened and it changed the relationship and it was a problem. And she really was between a rock and a hard place with trying to cooperate with the time sharing, but also protect her son. As to the income.
Go to court and seek a court order before making the decision as to when he would be allowed or not allowed to see the son?
So there was a temporary order entered, but other than that, no. And that was just kind of due course of a proceeding. As to the income, we completely agree that the statute controls. If there are any questions on that, I'm happy to answer.
Now, let me ask you about the other item as far as the preparation of the final judgment. So, I mean, obviously, the original final judgment was much closer to the proposed final judgment than the second amended final judgment. And you all argue in your brief about, how much weight should we give to the fact that the judge made more changes when doing the second amended judgment than the original one. So let's hear your position on that.
Yeah, so the problem there is that once the court entered their original judgment, the positions were already baked in. My client was then having to prove error on remand, and the court went back and addressed some of the more obvious blatant omissions, but it was, but we don't think that was enough, adding some bolstering reasoning when the judgment is still that drafted by Mr. Gillis's counsel, and that's only one factor that the courts look to. It also looks to
Parties, another way to look at it is that the parties, out of multiple conceivable options that can go on in a high conflict divorce, they'd resolved equitable distribution, they'd resolved alimony, and they'd resolved attorney's fees. So another way to look at it is that you've got a judgment that just basically has two issues in it. You've got parenting, and you have the child support, which is the imputation of income issue. So if the trial court is just deciding two issues, it's not as if that there's a lot of give there, especially with the starkly contrasting options that your client and Mr. Gillis gave the trial court. So I don't necessarily know about that argument about positions being baked in, and I'll ask you to comment on that in a second. The second thing that I want to address is this all comes from a Florida Supreme Court case that seems completely different from the one that we have in front of us. And I think even the Florida Supreme Court came back 4 years later and just said, there's nothing wrong with autographing a judgment, if that is indeed what happened here. It's giving the other side no opportunity to respond to it. So I struggle with the argument in the brief that a very well-represented party below, having read the transcript and having read everything, only had 2 business days to object. He had an opportunity to object, and then he did object on rehearing and won. So I'm struggling with the underlying aspect of Perlow as modified by Strand, that this really is about an opportunity to object, not about correcting errors, which you're trying to do separately.
I agree with the point that the opportunity to object is one of the critical point. Here, I'm not sure 2 business days is enough, especially with 45 pages. There's not evidence in the record to show what was happening during that time, but, you know.
Not trying to be argumentative with you, but the rule itself gives people 15 days to move for rehearing, and there was no problem doing that. So I think that you're probably in a position where you have to advocate for more time between two business days and the 15 running days. And it makes it hard for us to say that, well, 7 is appropriate or 10 is appropriate, because it comes from a Florida Supreme Court case that just says opportunity. Because in Perlow, it was 2 hours after it was over. It was a pro se person on the other side who was specifically told, I don't want to propose judgment from you. Whereas your client, and I recognize that you weren't the counsel below, but I thought he did a very credible job in putting together as large a judgment and submitting it at the same time frame. So I'm just not seeing, I should say I'm struggling to see the lack of opportunity to object.
Well, as to the, okay, so I'll try to address that.
You rambled a bit.
The first point is, I don't know if this court has to draw a line in the sand as to how much time is and isn't, but I think 2 business days is probably not enough. There's just so much that could be going on with schedules, and the council didn't have, what have you. We don't have evidence in the record as to what happened there, but the second thing is that there are cases that are further from Perlow that we've cited where both sides submitted judgment, the court adopted it, the reviewing court still found that there was a lack of independent decision-making. And I'm not saying a court can never adopt a proposed judgment, but there needs to be an opportunity to object. And also, just blatant one-sidedness, errors in the judgment, all of the other issues go into it as well.
I think one thing we look at too, and this will be my last comment on judgments, I think one thing we look at too is the level of involvement that the trial judge had in the particular case. And it seems to me that if I look at the series of questions that he asked your client at the end of her examination at trial, we can kind of glean what his mindset was in entering the judgment. And again, I don't think it's my province or our province to say whether we agree or disagree with that. We weren't there. We didn't hear the evidence. But it seems to me that if you look at those questions, you might be able to glean why the trial court did what it did. I would struggle to call this, in an opinion, an uninvolved trial court.
Just quickly on that, I agree the judge was active during the trial. I think that actually raises more questions because in the judgment that the court initially adopted, it didn't address things like the testimony of the son. There were errors. It didn't really address the fact that Ms. Edie had been a primary caregiver during the entire party's marriage. Then when Ms. Edie pointed out that the judge shouldn't have just adopted the judgment, the judge did go back and make some errors, like I said, but everything in our view was baked in at that point.
All right, you're at 3:40 now.
Thank you. I'll reserve the remainder of my time for
All
rebuttal.
right, thank you. May proceed.
Good morning. My name's Richard McKinley. I'm here on behalf of the appellee, Adam Gillis. I want to go first to the questions that address the imputation of income because I believe that at page 52 of the appellee's brief, there was a reference to the statute that the court inquired about. There also were questions that the court or the panel put to appellant's attorney about the imputation. And it's...
Let me ask you this. Under the statute, you can't impute income more than the highest income the person ever made with certain exceptions. Is it your position that one of those exceptions applied?
Yes, sir.
If so, what exception?
Well, in this particular case, I looked at the Brennan decision, which was cited in the brief. And in Brennan, the mother had been a stay-at-home mother. And it's cited in the brief, but it's at 184 Southern, which is the 583. It's a fourth DCA case. She had a master's degree, was a licensed speech pathologist, and had chosen not to work during the course of the marriage. There had been a vocational expert who testified, presented evidence of open positions in speech pathology for which she was qualified. The pay range of $47,000 to $50,000 per year was the testimony in that case, and the imputation was at the number 48,000. And
But here the wife had worked during the marriage, correct?
I
Here the wife had worked.
I wanted to make sure I heard the question correctly. Yes, she had. She had a history of working that was exhaustively detailed in the statement of facts in the Appellee's brief. She had worked in 2012 in sales and pharmaceutical sales. She had worked in sales with the Delta investigations. She had worked as recently as 2016 or 17.
Had she ever made $80,000 a year at any of those jobs?
The trial court actually found 68, and I think I'm stuck with that. There were W-2s and things like that that suggested 77, 80, 81, but the number that the trial court found was the highest she made, and this might have found its way.
And were there any certifications or relicensing or things like that after?
No, sir, but
After that income, after her highest income earning year?
no, sir. But the vocational expert had spoken to an inflation adjustment factor and an inflation consideration in arriving at her 70 to 100 presentation,
Let me ask you this.
which was her range, the range that she testified to.
What was the evidence as far as 6 months to a year before the petition was filed? What were the relative incomes of the two parties?
6 months before the petition, she was unemployed.
And how about him?
He was employed. He was working with Delta Investigations, making several $100,000 per year. He was the primary wage earner at that time.
And then the trial judge imputed the same amount to each of them.
Yes, in his circumstance,
Make sense to you?
under the facts, yes.
You wrote it, so I guess it does make sense to
Well,
you, but
It's not my judgment, it's Judge Mosley's judgment.
who
but
prepared the,
I
That would be you.
drafted the one closest to what was entered, which is,
Just don't see how you get around the statute. I mean,
Well-
if we had to follow a fourth DCA case, which we don't, there's nothing about it that you said could get us around the statute. And if I look at the statute itself, it just simply says, can impute income higher than the highest she's ever made. I recall 65, but I also missed your reference on page 52, for which I apologize.
no, that-
I just don't know how you get around the statute. Which draws me back to Judge Evander's question, which is, which of the exceptions apply? And it doesn't sound like any of them do.
your point about the statute, when I read it, it seems pretty bright line, and I think your observation may be well taken, and it's an uphill climb for me.
so you want to start this, argument with that, of all the issues that are in this case, that's what you want to start with?
I wanted to speak to,
All right, well, let's speak to
Judge,
some
okay.
other issues, though.
yes, sir, and
Yeah, I am struggling with the fact that at least 3 times in this final judgment, the court referenced the filing of a petition for relocation that subsequently had been withdrawn. Why is the mere filing of a petition for relocation held against a parent for purposes of determining shared parenting?
The facts of the case were that the petition for relocation was filed on the eve of a temporary hearing where the father was attempting to obtain time sharing. That petition for relocation was actually heard for purposes of determination of whether or not to enter a temporary relocation permission order, which is provided for by the statute, and was denied. The initial request for relocation was denied. The petition for relocation sought to relocate to Charleston, South Carolina, which is a distance which prohibits any local time sharing order. And there was no effort to obtain entrance into any.
It just seems that concept that we're going to punish someone for filing a petition for relocation after it's been withdrawn, I struggle with that concept.
Am I correct that the court's inquiring as to the relevance of that? Is that the
Well, I understand
basis?
your argument as to the relevance. It just seemed punitive, and it seemed like it was mentioned, numerous times during the course of that final judgment.
The court's intent, I can't glean the court's intent beyond what is referenced on the four corners of the final judgment itself. And the court apparently.
You drafted most of this. I mean, there was very little difference between your proposed final judgment and what the court entered.
The second amended.
I'm giving you great authorship, of that final judgment.
Your Honor, the case law is clear that even the verbatim adoption of a final judgment is acceptable.
That's not the point of the question.
But the suggestion that it's my judgment versus Judge Mosley's judgment, I just have to disagree with that. I
think that the question is, since you drafted a proposed judgment, in essence implying that it should be held against her that she filed the petition to relocate, the question is, is that an appropriate argument? Is that an argument that has merit?
I would submit that the fact that she held against her, I wouldn't frame it that way. The fact that she, on all these circumstances, given all these facts, with an ability to work and to make money, choosing to go to school for 3 years where she wouldn't be making money, where she would be spending $100,000 or more, was not a practical.
Doesn't she have a right to look to her long-term, path in life? How long do you want to continue in pharmaceutical sales? I mean, if she wants to be a lawyer, then why shouldn't she have the opportunity to do that? She has the rest of her life that
Because
she's going to have to.
She's
going to have to earn an income for the rest of her life. She might not start out at the same level.
We have 2 children, one of whom was 14 at the time of the final hearing. She wouldn't even approach entry into the job market as a lawyer until that child was 17. She, as a parent, has.
Just about the kids, though. She has a right, I think, independent of the children, to look at her long-term economic best interests.
And she has an obligation to take care of her children and to support her children to the extent that she can during their period of minority. And the fact that.
How did that work for him when he leaves, this didn't get litigated, but he leaves a job, the question is whether he was fired or whether he quit, he leaves a job making, almost $400,000 and starts a business earning $60,000. Doesn't that same analysis hold true for him?
His move didn't, well, number one, the trial court obviously made a finding that his departure from Delta wasn't voluntary. And,
Based upon, he said, she said.
well, which
Nobody
is
was
the trial
called-
court's,
Nobody was called from Delta. And, this wasn't litigated. It's just, quite frankly, surprising to me that issue didn't come to the forefront, because it had an impact upon everything else that occurred during the course of this trial. And as Judge Evander noted, we've all sat on the family law bench, and this isn't the first time we've seen people come in right before a divorce and all of a sudden their income is decreased dramatically.
that's not what the evidence was in this case, respectfully.
And
What-
so,
what-
so the wife testified that he had told her he was going to leave.
And his testimony was that he had been alienated from the company, which was a company owned by his father, and
Maintained a 33% ownership interest in.
which had been resolved at the outset of the trial. And why the wife's counsel did not present contradictory evidence
Let me
from
move to-
Delta.
All right, let me move to one other issue
Sure.
that seemed to be difficult for me, which is the finding that she had talked to the son about the case. Where in the record was that evidence?
There were three aspects of the record that strongly supported the suggestion
It was
that
an inference.
inference, and
Okay, but because that's really not what the judgment said. It didn't say, I'm inferring that. It seemed to indicate that she had, but go ahead.
And I would argue that the court is entitled to draw inferences, reasonable inferences from the
From what
evidence.
facts?
And what we had in this case is we had the wife's testimony about computers and a photo library. We had the child actually offering from that computer and the photo library pictures that the wife had taken in 2016 and 17 to detail that my client was not a good housekeeper. There were
Bob, I think is how he referred to himself.
right, but they were the wife's photos on her computer.
What was the third?
I'm sorry, sir.
Three things that inferred she had talked.
Well, the second was an email where the temporary order had been entered where
He
she,
says he doesn't want to go on visitation.
well, and it says Jackson has expressed to me a number of times, and that this new schedule isn't working for him.
And so that's an inference that she was talking to him about the case?
I believe that that fact, based on all the other circumstances of the case, suggested that the two were interacting, and the fact that the testimony about the incident between him and my client and the manner in which he resisted the time sharing.
All right, go ahead.
Were there other issues that the panel wished to inquire about?
Well, I have one other.
Yes, sir.
You think that bringing a new girlfriend into time-sharing exchanges doesn't typically cause issues?
As someone who has litigated matrimonial matters and custody matters for a long time, it's not necessarily something I would recommend, and it's not something that I would urge. Having said that,
And I think you're absolutely right. Again, we've all handled a lot of family law cases, and yet, in that judgment, former wife was criticized because of, not allowing the new girlfriend to participate in, or not allowing, but to have issues with the new girlfriend, being involved in the pickup and drop-off on time sharing.
The evidence was much beyond just that she didn't allow her to participate. There was evidence that she was filmed during the exchanges. There was there was evidence that the hostile is a strong word, but the wife was absent.
Suggested that you know, that is not uncommon in these cases when you bring a new girlfriend and put her into a position of involvement in that respect, that you're going to have these types of conflicts, and yet the judgment was critical of former wife, but not critical of former husband for letting that occur in the first place.
Respectfully, the trial judge was closest to the evidence about those exchanges and what particularly happened during those exchanges. And it was within the umbrella of his discretion to consider the evidence, to weigh what was going on there, to consider it, and to resolve what conclusions to draw from it. The other evidence was that the new girlfriend, as you framed it, was...
She frames herself as doctor. Even they ask her name, and she
Well,
says doctor.
She is, in fact, a doctor.
I know, but that's not her name, is it? I mean, you know,
Her name is...
I don't introduce myself as judge.
No. Well, different people approach those sorts of things differently, Your Honor, but her name's Casey Mixon, but she was not somebody who came on the scene at the outset. She wasn't someone who was there 4 months after. It was more like a year. It was, and which is a circumstance that I submit that the trial court would have been entitled to consider and weigh in how to frame what was going on there and how to consider what conclusions to draw from it.
Yeah, I think, you know, my concern on cases where both sides prepare proposed final judgments, you know, you look at the time share, the time, you know, sharing the visitation exchanges. You probably have bad conduct by both sides, and I assume the proposed final judgment from one side just references the bad conduct by the other, and vice versa. Because if he shouldn't have used her for the timeshare arrangements, and she shouldn't have filmed the new girlfriend, I mean, there's bad, you know, there's mistakes by both parties. And one of the problems with doing, you know, proposed final judgments, as was done in this case, where both sides submit one-sided proposed final judgments, and the judge signs one, is it creates this type of situation where you have cases that may, you know, probably tilted a little more to one side than it should have been. And, you know, that's a concern I have. I personally, I really dislike the idea of requesting proposed final judgments from both parties, because inherently both attorneys feel the obligation to make it one-sided. And then when the judge pretty much signs one of them, it tends to come out a one-sided judgment. I mean, I have major concerns of how you could have someone making $300,000 a year, another person making zero shortly before the petition, and then somehow they're both imputed at 80. I mean, that's just not right.
I think there's, to expand on that briefly, I mean, I think you've got a tough position, as all trial lawyers do, of being advocates for your client while simultaneously preparing a proposed order or a judgment for a trial court to sign. And I understand your argument that Judge Mosley adopted some, if not all, of your findings, probably closer to if all, but I wonder if in the future you would put it, that you would write it so one-sided, or even if your colleague below would have written it so one-sided, because it puts you in a position of having to defend it against Perlow, which I think you can, from the context of my comments to your colleague, but it puts you in a really bad spot.
I understand your observation, Judge Traver, but in this instance, the second amended final judgment reflects that the judge entertained the positions that had been advanced in the motion for rehearing, considered them, and there were significant changes, not in the conclusions, but in terms of the fact findings, there were additions there, which to me, it makes it where the appellant cannot overcome the hurdle of they can't show that this is not Judge Mosley's independent decision. And I think I've expired my
Yeah,
time.
you have, and thank you.
Exhausted it. I appreciate your interest. Thank you.
All right. I'll give you 1 extra minute, so you have 4:38 left.
Thank you. 2 points. One, all of the evidence that this court drew out that it has concerns about is evidence of the one-sidedness in the judgment. As to the relocation, Ms. Edie was trying to figure out what to do after things really shifted for her. Mr. Gillis was permitted to open his own business, making $60,000 a year.
Y'all didn't litigate that. You know, that was not litigated. And I understand, that would be a real concern for most trial court judges, but that was not an issue below, nor is it an issue that we have for resolution on appeal.
We're not trying to overturn any determinations on his income or anything like that. It's just evidence of how one-sided the judgment was, which goes to the independent decision-making of the trial court.
Or maybe it goes to the credibility determinations that the judge made.
As to,
Yeah, see, my comments are, I really don't like that both sides prepare proposed final judgments, but from an appellate perspective, we got to look at what evidence did the trial judge had, and we have to give the trial judge the benefit of credibility determinations. And, on the time sharing, good argument can be made that whichever way the judge went, there's going to be evidence to support it, which is often the case in time sharing disputes.
so I think before this court gets to the abuse of discretion inquiry, there is a preliminary step, and the court has to be satisfied that the court actually exercised its discretion in the first place. And that's the step we're at. A lot of this, we're not quibbling over whether there was record evidence or
Well,
not.
the judge's questions to your client at the end of the case were certainly not the result of any proposed final judgment, right?
I'm sorry.
The questions that the judge asked your client during the case, which suggested concerns that the judge had about your client's plans and your client's parenting ability, those questions came from the judge prior to receiving any proposed final judgment from the opposing party.
Yeah, yes.
So
that's
that would be a pretty good indicator that on the time-sharing issue, the judge had a pretty good idea or definite idea on concerns that he had about your client.
Well, one point on the time-sharing issue, it's not all or nothing, as this panel well knows. The time-sharing is so one-sided in favor of the husband. The court could have come to a different conclusion on that that never changed between the original proposed judgment, original judgment, the amended judgment we have now on appeal. In the last few...
But the time sharing in part was a reflection of your client's positions taken in terms of their schooling. And the judge certainly was concerned about the education and the path of education for these children.
Well, the court could have rewarded primary education, parental responsibility, and it did to one parent or the other, but still have more equal time sharing than was entered.
Did you happen to read the proposed final judgment prepared by your client's trial counsel?
Yes.
If the trial judge would have autographed would there have been substantial competent evidence in the record to support the determination? I mean, I think that what I'm getting at is that the parties to this lawsuit presented 2 starkly different choices to the trial court and effectively told him to pick one or the other. And this is how it ended up.
Just if I may, the court actually invited the parties to submit them. That was the court's request.
And we've criticized that request.
Okay. If there are no other questions, we ask that you vacate the portions of the judgment identified in the brief and remand. Thank you.
All right, thank you both. Court will be in recess.